welcome by Mr. Robert Amukboro joins us this morning. He is a senior advocate of Nigeria. Good morning, and thank you for joining us on the program today.
Good morning, and thank you very much for having me.
Yeah, so a lot of focus on the judiciary in terms of what conduct, what is expected of them by society, the perception of judiciary by members of the society. And, well, let me start with asking, we're getting some distortion in my ear. Just trying to find out from you, Mr. Mukbaro, concerning this judgment, now that it's out there, we still see today several dailies reporting that customers are still trying to get access to this cash in many of the places there. Another daily was talking about how CBN is mum. Yesterday was people waiting on what the president would do. And so it just sends a message and people wondering, when this kind of judgments are handed down, how are they supposed to be executed? How should the society respond to them? So from what you've seen, is it appropriate how everyone should respond to this judgment?
Well, that's a very good question, because really, we've all heard about the judgment, but I dare say that very few people, if any, has in fact received the judgment and read them. Because when you talk of enforcement of a judgment, I think what should precede that is really people having complete knowledge of what was really decided. I have myself not had access to a certified true copy of that judgment. I do not know whether the parties that are meant to enforce the judgment, whether they also have a certified true copy of the judgment. Because the issue you have really touched on is a very crucial issue. It's really an issue of enforcement by the provisions of the Constitution. Every person, every authority must enforce the judgment of the Supreme Court. But I think the critical issue is really what are the terms of the judgment for the purposes of enforcement, because what is out there, if I may use that phrase, is really what is being reported, and that is not really the judgment itself. I think that may jolly well be what the real problem is. I do not think that the Central Bank of Nigeria has a certified true copy or has been served with a certified true copy of that judgment. I doubt very much if that may well be what the problem is, because they need to act on some document that spells out terms of that judgment, I think, yeah.
So does it then mean that, assuming they don't have a certified true copy of the judgment, their lawyers were in court, clearly. So yeah. What if, probably without them getting a CTC of the judgment, and then they get a directive from the executive arm, go ahead and do certain things, would they do it without getting a CTC?
Of course, if for example, the Central Bank of Nigeria gets a directive from the president to go ahead and do it, they are bound to do it. Because really what was in issue in that case was really the exercise of statutory power by the president, and that exercise of statutory power by the president was faulted correctly by the Supreme Court, that he more or less, I think it's really revolving around issues, whether you say there was an excess of power or an abuse of power or usurpation of power, but somewhere along the line, there was a need for judicial intervention in how that statutory power was exercised by the president.
So talk to us about this, because lawyers seem to have different opinion concerning whether or not the CBN is a party to it, how they should conduct themselves, if they were not a party or if they were a party. While some others have said, well, yeah, but the fact that even if they were not directly a party, this has to do with them. And so if they benefited from similar scenarios without being parties, being a party in this matter shouldn't be a challenge. How should these things be? What is the appropriate thing to be done?
I think the question you have touched on actually throws up the, uh, the role of the Central Bank of Nigeria within the scheme of the Central Bank Act of 2007. And of course, within the backdrop that the central bank is meant to be autonomous and independent. But the truth of the matter is that it is not in every respect that the central bank is autonomous and independent, even under the CBN Act itself. With regard to coinage, with regard to currency and legal tender, whatever powers the CBN exercises is based on the directive of the president. And that basically recognizes the sovereign, so to speak, power of the president as the chief executive under Section 5 of the Constitution. So with regard to currency, legal tender, and coinage, it is the president that issues this directive to the CBN, and it is meant to carry it out. So it is within this context that I will proceed that, of course, the Central Bank of Nigeria was not a necessary party to that action. It is with regard to the exercise of the powers relating to currency, legal tender, and coinage, it is the president that has that power. So the question of joining the CBN as a party to those proceedings simply is not tenable. It is the president that exercises the power, and the Supreme Court has held that the president did not exercise that power within the limits of the law, within the provisions of the Constitution. And that was why they intervened and set aside the exercise of the power.
Well, a colleague of yours, whom we spoke with yesterday, had a different opinion on that, and he kind of thinks that it's possible that might be the reason why we were yet to see any directive issued by the CBN to the banks, for the expedited, will I say, implementation of the Supreme Court order. That it was the fact that it was taking this long, was owing to the reason that the CBN governor, or beg your pardon, the CBN as an institution was not joined in the matter. I don't know. Can you hear me? Mr. Emokoro, can you hear me?
Well, I cannot hear you fully, but yes, I heard a bit of what you said.
Yes.
I don't know if you are hearing me. I heard a bit of what you said.
Yes, I can hear you.
Okay, very well. What I can say is that the central bank governor itself acted on the directive of the president to initiate this demonetization policy. So I suspect that the central bank governor is merely awaiting the directive of the president on what next to do. It wasn't, I don't think it is because the CBN is not a party to the proceedings. I don't think that's the reason why it is not complying with the order of the Supreme Court. It will comply with the order of the Supreme Court. It is bound to comply with the order of the Supreme Court. Otherwise, what are we? It's like inviting anarchy. The Supreme Court's judgment is final. No contrary opinion can be expressed to that of the Supreme Court so far as the issue of enforcement goes. So I do not know what other contrary views have been expressed. Whatever the Supreme Court has decided on this subject matter, there is a finality to it.
Well, we understand that the Supreme Court, had some pretty strong pronouncement in respect of this matter. They do not expect that in future that the president and the CBN governor would just be able to have a private conversation and issue a policy from it. They're hoping that there will be a further conversation with the states. But in future, if this sort of conversation is to be had, is there a prescribed procedure for how this should take place? Mr. Mukuru, I don't know if you can hear me.
I think the Supreme Court itself, yes, I heard what you said now. And my response is that I think with regard to procedure, The judgment of the Supreme Court has enunciated the procedure to be followed. From the little I have gathered from the press, the Supreme Court has clearly enunciated procedures to be followed before this kind of policy can be put into effect, by making reference to the National Economic Council, the National Council of States, and in fact also the Federal Executive Council, to be consulted before such a... So a procedure has been enunciated, and in even prescribing December 31st, 2023, as being the period for the I don't know if you are hearing what I'm saying.
I can hear you, sir.
Okay, so for the demonetization to take effect, it has also more or less set parameters for what should be deemed to be reasonable notice. Because these are part of the conditions. These are part of the conditions that are even embedded in the CBN Act itself. For that power to demonetize to be exercised, reasonable notice must be given. And the Supreme Court found that the 3 months period given is not reasonable notice. We can also hazard a guess that the date of December 31st seems to suggest that reasonable notice should be nothing less than 1 year. I think we can deduce that much from that decision of the Supreme Court. So in effect, the judgment of the Supreme Court itself has encapsulated what, as we have described it, will be said to be the procedure that should be followed when such a policy is to be done in the future. So until we see the judgment of the Supreme Court, we will not be able to fully know what this procedure is. But I believe that the Supreme Court has set out what must be done in future whenever this kind of thing is to be done.
While the conversation raged on about, jurisdiction, whether the Supreme Court had jurisdiction on this matter, and eventually the Supreme Court initially, ordered a stay of action pending when all the parties in the suit will be joined, and eventually they will set a hearing date for it. There was big conversation even amongst the legal community as to whether that's stay that the Supreme Court had given, whether it meant that the old Naira notes could still be spent. And there was a big conversation on whether or not, I know that the conversation went back and forth. That's what I recall in this particular instance. As a lawyer, watching what happened in the courts, especially at the Supreme Court, how concerned were you about the sort of conversations that we were having in that period, not only around jurisdiction, but in terms of the interpretation of interim orders given by the Supreme Court, pending when it heard the full details of the matter before it?
Well, I think the concern with regard to jurisdiction, I think it was a well-founded concern, because I believe that the initial understanding of most people was that this was a power that was exercised by the Central Bank of Nigeria. And with that at the back of people's mind, the question was now, how do you fit in the Central Bank of Nigeria within the very limited original jurisdiction of the Supreme Court? Since the constitutional provisions dealing with the original jurisdiction of the Supreme Court talks in terms of disputes between the states, disputes between the states and the federation. And the question was now, on this specific issue, can it be said that there is a dispute between the states and the federation? That's why I said, well, the conversation around the issue of jurisdiction, I felt was a bona fide conversation on whether or not the Supreme Court had original jurisdiction. Original in the sense that you can approach the Supreme Court as a court of first instance. Is this a dispute in respect of which you approach the Supreme Court as a court of first instance? Because usually the jurisdiction of the Supreme Court is an appellate jurisdiction from decisions of the Court of Appeal and some other other bodies that can appeal directly to the Supreme Court. So it's usually appellate. Supreme Court does not act as a court of first and last resort.
So that is on the matter of jurisdiction. The second is on the matter of the, will I say, the interim injunction granted by the Supreme Court, pending when all the processes had been filed before it.
Any decision of the Supreme Court, whether it is an ex parte decision or, as we have correctly observed, an interim injunction, also enjoys the sanctity of the provisions of Section 287 that enjoins every authority and every person to enforce that order. So it's rather quite disheartening that people didn't see the Supreme Court's ex parte order as an order that must be obeyed. It must be enforced. It must be complied with, whether you agree with it, whether you don't agree with it. Because the Supreme Court is the apex court in this country. And it is there to ensure that, look, there is sanity in society. So when they make an order, you may not agree with it, but you just have to, in the larger interest of the society, you have to ensure that that order is obeyed to the letter. All right. So it was really quite disheartening that the president, after that order was made, read a broadcast in which he more or less disregarded the order. I don't think that was right. That was most unfortunate. And I think it played a lot of role, ultimately, in the judgment that the Supreme Court handed down.
All right, let's bring in my colleague in Lagos. Ayo, go ahead, please.
Mr. Okoro, you know, first of all, just for the purpose of understanding, when you talk about the jurisdiction in the light, or that you spoke about it, there are many people, as my colleagues have told you, who are at variance on where what is. So in terms of jurisdiction, at what point or in what instance is the Supreme Court the court of first, in what case does the Supreme Court have original jurisdiction? The understanding people have had until now is that if it involves the federal government and the states, that's an original case. So just for the purpose of understanding, what's the real case? Federal government, federation, and the rest of that? Can you hear me, Mr. Mukuru?
Parts of the Constitution is that when there is a dispute between the states and the federation on any issue of law or facts concerning the existence or non-existence of a legal right or a duty, the Supreme Court has original jurisdiction, that it is the court of first and last resort. But the issue here is really to appreciate that the Central Bank of Nigeria, for the purposes of the dispute that was taken before the Supreme Court, was merely seen as an agent of a disclosed principle. And that principle technically can be said to be the federation.
Well, there is also that argument
and I suspect that that is the reason why the Supreme Court found that the exercise of the powers of currency, coinage, and legal tender is not one that can be exercised between the president himself and the CBN governor. He has to consult with the National Council of States, he has to consult with the Federal Executive Council, and he has to consult with the National Economic Council. Because this is a federation issue. It is a decision that touches the entire federation.
Well, the argument of
let me make one point. So people also are rather oblivious of the fact that even state governments, they also have a right to cash. They have a right to have accounts. So it is a decision that affects a state in its status as a state. So when you impose cash limits, it affects the state government itself.
Okay, just again, for clarity, your understanding or interpretation of the position of the Supreme Court when it says the federal government is an agent of the federation and that
The
the
central
acts...
bank.
I'm building up to somewhere, sir.
Okay.
What the Supreme Court said, the federal government is an agent of the federation, and the acts of the federal government are the acts of the federation, and as such, the suit as filed was purely a dispute between the federating unit and the federation. Accordingly, the Supreme Court held that it was indeed a dispute within its original jurisdiction. Does that settle that matter?
Yes, that's what I actually tried to explain.
Okay.
That this was the exercise of powers on behalf of the federation.
Okay.
Now, it affected the states, so that is what led to the dispute.
Okay.
So that within the provisions of the Constitution, this was a dispute between the states and the federation.
Okay. Now, to the issue that you mentioned the other time, that the federal government, I mean, since it concerns the federal government and the states, I'm wondering whether you thought, I mean, you know, there is a process in law that mandates the president to have consulted with the states before that decision was taken. The CBN Act is clear that the CBN governor has to, the president has to agree with the CBN before any action around the currency notes and all of that can be taken. Now, but I'm not sure whether there is any law that says that the president should consult with the states or the Council of States as now pronounced by the CBN. So in that regard, would you say the president was out of order in the first place and that the councils around him, including the AGF, were in the wrong? Or, as some claim, deliberately misadvised the president?
Well, let me answer this question by first and foremost making some clarifications on the initial statements made. Under the provisions of the CBN Act, it is not for the president to agree with the central bank. The central bank will have power if the president directs. Those are the express provisions of the law. The president directs the CBN on this issue of legal tender. So it's not a question of the CBN doing something and the president agreeing. You know, the CBN acts on the directives of the president. So that is that. Now, with regards to the issue of consultation with the National Council of States and other bodies, I am personally when we connection between the National Council of States and other bodies that the president, that the judgment of the Supreme Court has, so to speak, mandated the president to consult. Because that pronouncement of the Supreme Court in their judgment now represents what the law is in Nigeria with regards to demonetization. It is now what the law is. That is what stands now. But I cannot, sitting here now, really mention the specific legal provisions that makes it mandatory for the president to make this consultation. But the effect of the judgment of the Supreme Court is that the powers that the president exercised was exercised contrary to the provisions of the law.
All right, so on a wider, broader scale now, just looking at how things are playing out in society, I'd just like to find out, since, you call it the Temple of Justice, one who is there, does the court consider things that happen in society before they reach decisions? Because there are different perspectives on this matter.
Well, one of the things that the Supreme Court says these days is that it is a policy court. They've said it several times. Personally, I have tried to find out whether the Constitution has provided that it is a policy court or whether the Supreme Court Act itself has provided that it is a policy court. But I have not been able to lay my hands on any specific provision of any law that says it is a policy court. But it sees itself as a policy court, which means there are certain decisions that it makes as a matter of policy. Who formulates that policy, frankly, I don't know. But what that indicates clearly is that the Supreme Court itself is not oblivious of what is happening in the society. And if it believes that there is a need to respond to some critical issues in society, I think it can always do so by way of these judgments that are now described as policy judgments. There have been policy judgments before in the past. It's not
okay.
new.
And you know, I raised that because, yeah, pardon me. For instance, when certain decisions are taken, and I'm talking broadly speaking now, when they are taken in court and members of society don't agree with that, and it's not that it's just maybe a small section, and this appears to be larger section of society, and you know how it is. I mean, lawyers will say laymen, and then probably this is where that maxim where they say justice doesn't only have to be done, it has to be seen to have been done. So for a lot of people, they seem to have this impression that judgment over time in different courts, they have this impression that the courts are not actually there to perhaps ensure that justice is seen to have been done. And for a lot of people, they feel they've made up their minds about that, nothing anybody can do from the judgment they've seen. And so when people tell them to go to court, they seem to be saying, look, because they know that they won't get anything from courts, quote unquote. Again, this is their own impression of this matter. So that's why I ask, so for this kind of scenario, does the courts, do they factor those kind of sentiments or comments or impressions of members of society when certain decisions are taken? Because it turns out that sometimes you might be in circles where you're overwhelmed with people who say they don't believe that they can get certain things in court. So how should one approach this kind of scenario, for instance, members of the profession?
Well, I think the first thing I will say to that is that, justice is not in the air. It has to be justice according to the law. This is the oath that the judges and justices have taken. They have to administer justice in accordance with the law. Now, the law may not be too popular, and it may not work favorably to very many people. But, in those circumstances, the judges and justices are circumscribed by the law. So they can only deliver justice in accordance with the law. They cannot go against what the law has provided. So that is the first thing that must be understood. That the fact that people are talking about justice, they must understand that justice can only be administered within the ambit of the law. The judges or justices they simply cannot go outside the law to administer justice. But there are instances, there are occasions where perhaps there may be some room for them to, hearken, if I may use that word, to what you are referring to as the popular views of people. If there is room for that, well, that means they have a bit of discretion. In areas where they have a bit of discretion, then I think they usually, generally speaking, will exercise their discretion in a way that society will benefit more from it.
So
but they cannot act outside the law.
Yeah, as we wind down on this one, there are several times when judgments are handed down at different levels, and members of society, of course, if they have questions, and media will certainly have questions because they need to present questions of members of society to the judiciary. Do you think that at some point, I mean, since we're in a democracy, we've seen other countries adjust and amend how the judiciary is administered and such narratives? Do you think we should get to a point where judges should speak directly or indirectly or through agents or something to ensure that they explain some of those circumstances such that people don't keep running away with certain impressions they have of the judiciary, even sometimes of judges, who we've heard several people say uncomplimentary things about some judges?
I think it's really, the policy is really to maintain the impartiality of the judges. That is the reason why it is highly undesirable for them to, so to speak, descend into the arena by responding to every criticism, by trying to explain their themselves in respect of judgments that are, unpopular. But I think the best forum for them to explain themselves is in their judgments. When a judge delivers a very lucid and a very sound judgment, I think that's the best explanation it can give. It is where judgments are difficult to understand. It is where judgments, there are times you see you are confronted with conflicting judgments. These are I think, the difficulties that the judicial system faces. But I really don't think it's desirable for judges to go about explaining themselves, or explain yourself in your judgment, explain yourself in your ruling. If there is a dispute before you, if your judgment is sufficiently lucid and clear as to the facts, lucid and clear as to why you reasoned and came to a conclusion, I don't think you need any further explanation.
So if they have spokespersons who speak on their behalf, can that be tantamount to them descending into the arena?
I do not think spokespersons on behalf of judges explaining judgments. If there are other issues they want to explain, they are at liberty to do so. But with regard to specific disputes that have been adjudicated upon and in respect of which a judgment has been rendered, I don't know what a spokesperson is going to do better than the judgment or the ruling itself.
All right, then we'll have to thank you for talking to us this morning, Mr. Robert Mukbaro, Senior Advocate of Nigeria.
Thank you very much for having me. It's always a pleasure to be on your program.
All right, we will be back in a moment. Stay with us.